Call the meeting to order. We have the agenda to approve.
Move the agenda.
Second.
Motion's been made and seconded to approve the agenda. All in favor indicate by saying aye.
Aye.
Opposed? Motion's carried. We have public comment. Just to note that the state board's agenda is full and may place limits on public comment based on the number of members of the public who intend to speak. I'll give each speaker 5 minutes, or if there's a lot of speakers, I'll limit that to 3. When your time is allotted, I'll ask you to conclude, and the board will move on to the next speaker. The department will not respond to public comment aside from requesting clarification. The department may place a topic raised in public comment on a future agenda. A topic from public comment is not related to an item on today's agenda will not be addressed at today's meeting. Do we have public comment today?
I have a public comment.
It's
Mr. President and members of the board and Director Lebo. I am Dr. Cynthia Knight, and I live at 607 Center Street, Union, Iowa. And I am a former Iowa Department of Ed employee, and I am the current owner of the founding group Choice Charter School. And I'm here to speak today to you about the proposed changes to Iowa Administrative Code 19, dealing with the charter school funding. When the legislators passed the new charter school legislation last year, I decided to create a charter school to help students who find the non-traditional students. And in accordance with the new school legislation, on March 24th, 22, the State Board of Education approved Choice Charter's application. And on April 20th, 22, the board approved the contract for Choice Charter. As you might suspect, to operate Choice Charter, I must provide staff and teachers and materials and computers. The contract that I have with the state estimates I will educate 300 students for this upcoming school year. These 300 students will come from all over Iowa. Some will be only need a few credits to graduate, while others may need a few years to graduate. Some students will drop out of our program, but as people learn more about Choice Charter School, I'm sure they will be new enrollments throughout the year. Based on my experience as an educator of children struggling in the traditional school, I guesstimated that my staff and I could educate 300 students this year. The state board agreed as reflected in our contract, so I have budgeted for 300 students. I estimate I will spend over $1 million the first 6 months and over $2 million by the end of the year. I'm not independently wealthy, and borrowing money for a program that's never existed is extremely hard. So cash flow during this first year is critical to the success of the charter school. Our staff expect to be paid their monthly salary, whether there are 300 or 250 students. Both the department and I estimated that I will educate 300 students this year, but I'm not naive. There will be months where I do not have 300 students on the rolls. There will be some months where I only have 200, yet the cost to educate 300 students remains the same. I cannot lay off a teacher 1 month because the student count goes down below 300 and then rehire when the count returns to 300. Reducing Choice Charter's income because we were successful in graduating students before the end of the school year does not make any sense. Yet the rules being proposed would reduce my monthly payment to account for that graduated student and my reduced student count. To help charter schools succeed, I propose for the first year, Choice Charter School be paid based on 300 students. I propose that the monthly amount not be reduced or increased based on the ebb and flow of the number of enrolled students. If at the end of the school year, Choice Charter did not educate 300 students, I would propose that Choice Charter School would either repay the state for the per student overpayment, or the Choice Charter's 23-24 payments would be reduced accordingly. As public educators, we all know there are students who are not being served by the public school. The reasons are varied, but the facts remain. There are thousands of children in Iowa who drop out of school every year. I want to help those children. But without your help on the funding, I don't think schools like Choice Charter have a chance at succeeding. I have provided a red line version of the proposed legislation with the changes recommended by me, and I'd be happy to answer any questions at any time, and thank you for your help.
Thank you. Do we have other public comment? Sir?
My name's Chuck Krieger. I'm a doctorate like my boss. I came here basically in support of her. I've probably been a teacher longer than some of you have been alive. Getting tired. I'm just saying, you've got something really good going here. Don't let her down. That's all.
Thank you. Is there any other public comment this morning?
We have someone on the webinar, Katie Grieving.
Okay, Katie?
Morning. Good morning, and thank you for the opportunity to make comments again today. I am Katie Grieving, Executive Director of Decoding Dyslexia Iowa, and I have offered comments at a number of your meetings this year. I am here again on behalf of thousands of Iowa families who have a child with dyslexia. And you might be wondering why I'm here yet again. Put simply, we are still waiting for the Department of Education to follow through with the Dyslexia Task Force recommendations. And if this sounds familiar to you, it should, because we have been bringing this matter to your attention for many months now. Remember that the Dyslexia Task Force report was issued in November 2019. Most of the recommendations were assigned deadlines in 2020 and 2021. The Department of Education's leadership staff served on the task force, helped craft the recommendations, and assured us they were fully committed to them. It is now August 2022, and most have not been done yet. For example, the department has still not issued guidance, dyslexia guidance to Iowa schools about using the term dyslexia, what to do when dyslexia is suspected, and what to do when it has been formally diagnosed. The draft guidance the Iowa Dyslexia Board received in the spring was problematic, and we haven't heard anything else about it. The recommendation to issue guidance to Iowa schools about how to better use universal screening data to identify children with characteristics of dyslexia has also not been completed. To our knowledge, the department has not hired a dyslexia consultant, even though we have been told for over a year that this was in process. There is still no Department of Education hosted website explaining Iowa laws and policies related to dyslexia. At a previous meeting this year, I was quite shocked to hear a department representative report that this recommendation was done because the Iowa Reading Research Center has information about dyslexia on their website. That is true, but that was not the task force recommendation. It is easy to find reasons for delays and excuses. The pandemic, too many recommendations, too many task force, too many things to do. And the Department of Education seems to be experiencing a high turnover in staff of late, but this can't be yet another excuse. When will we find a way to move the ball forward regardless of who is carrying it? One thing I know for sure is that when something is important enough, we make it happen. All of the Dyslexia Task Force recommendations were designed with one singular purpose: to help Iowa students learn to read. And the recommendations will help students with dyslexia and all struggling readers. And isn't that the most important purpose of our schools, to teach children to read? Can we really afford to wait any longer? Over the past 10 years, we have been very happy to work collaboratively with a variety of Department of Education staff, and we want that to continue. We would like an update from current leadership about what is being done to address these very serious issues. Thank you for your time today.
Thank you, Katie. Is there any other public comment this morning?
I'll just remind participants, if you wish to address the board, please use the raised hand feature at the bottom of your screen. And if you're calling in, you can press *9 to raise your hand. We do have another person willing to talk. It's Claire Salsi.
Good morning, Claire.
Good morning. This is Senator Claire Salsi calling from West Des Moines. I'm here in support of the dyslexia parents' requests. I've received a number of emails after the passage of our dyslexia legislation, which, by the way, was a very bipartisan piece of legislation, something that all of us were very proud of. Senator Jerry Bain worked on it for years. Before he retired, we finally passed it. And I'm very dismayed by the lack of seriousness, it appears, from the Board of Education and the Department of Education on getting this moving. So I would please urge you to do whatever you can to hire the specialist at the Department of Education. It appears that no one is really taking charge of this project, and that's the problem. So we need to get a specialist hired and get this.
You're muted, Claire.
Hello, I'm still here.
Yep.
Are you there?
You're back.
You're back, Claire.
Sorry, I didn't do anything. I didn't touch anything, so I don't know what happened. Anyway, what I was saying is I'm very concerned about the dyslexia task force's recommendations not being followed, and that there's no movement on this from the Department of Education. So I would urge you to please do so. I know that was the intent of the legislature because I was there when the bill was passed. So thank you very much.
Thank you, Claire. Are there any more public comment this morning?
There are no raised hands in the Zoom room currently.
Okay. Public comment has ended. We'll move on to the director's report.
Well, good morning, everyone. I actually want to start by giving a thank you to Carol, who hides in the corner, and her husband, Les, handyman Les, who comes in and helps and hung those lovely pictures of our board members on the wall and do a lot to help prep the work. So just a small token of appreciation, because that's certainly not in your job duties, but thank you. Just thank you for making some adjustments on the agenda. We have several staff who are at the School Administrators of Iowa Conference right now giving a presentation. For the past several years, it always seems to coincide with our board meetings, so it impacts our capacity to do both, but they will be here later to give some of the presentations, but they're doing a great job representing us there now. That's a gathering of all school administrators across the state of Iowa. Kind of is a great way to kick off the year. So they're there today, and they will be back here later to talk to us. I would also like to give an opportunity to welcome Dr. Kim Baranek to our staff. She started July 1st as our new division administrator. She is able to be here today, so I wanted to give her an opportunity to introduce herself to the board.
Good morning. It's a pleasure for me to be here today. I've been looking forward to joining all of you in this new capacity. Like Dr. Lebo said, I've been here a little bit over a month. It has been a great experience. Staff has been very welcoming, supportive, and gracious as I learn many, many things. And I realize this is a great place to work. Prior to coming here, I was the associate superintendent in Sioux City Community School District. I was there in that capacity for 8 years and 2 years as the director of curriculum instruction and assessment there also. Prior to that, I was a 6 through 12 principal at West Sioux in the northwest corner of the state. And prior to that, I was a high school principal in Montana. And my career started as a high school English teacher. So that's just a little bit about me. I'm married, have a daughter who's going to be a freshman in high school. So we will be clothes shopping for the next several weeks to get ready for that. It's a pleasure to be here, and I look forward to working with all of you as we have a positive impact on children in Iowa. Thank you.
Welcome, Kim.
Thank you very much.
It's sales tax holiday, by the way, this weekend.
It's a time to shop.
Shopping early.
A couple other updates I wanted to go over. At the last meeting, I talked a little bit high level about some of the school safety initiatives that were going to be coming out. It was announced officially after that meeting, so I wanted to make sure you were all aware of the detail. This is $100 million that was invested by the governor, and it's broken down to several different categories. Because the department is playing a role in this and communication with schools. I want to make sure you were all aware of it as well. Here's the kind of the high level breakdown. 75 million of this will be for school safety improvement fund. What that means is that schools right now contacted the department and asked for a vulnerability assessment. The vulnerability assessment is something that can be conducted by Homeland Security. They also have a contracted team, or maybe it's something school districts have already done previously. It's an opportunity for law enforcement to come in and partner with the school and assess their grounds, assess their safety. From this assessment, whether it's conducted by Homeland or independently, the district would then be eligible for up to $50,000 per building for improvements based on that assessment. So it's a tremendous investment. And we know that schools aren't just starting to think about school safety and aren't just starting to do things, but this really gives an opportunity for them to further enhance or leverage some changes that are needed in their buildings. That's a huge project that we're helping support now. Our role really is the communication piece to make sure we're getting information from the school districts to the School Safety Bureau. A new bureau has been created to lead this work that will be housed in public safety, and we have a team internally that will partner with them. So incredible opportunity to make some changes that are best for the districts for those funds. A couple of the other pieces then will be part of the money then is going to pay to cover for those assessments being done, obviously. Another piece that we at the department are going to help fund through some of our relief dollars or something called critical incident mapping technology. What that is basically kind of a digital map of a school system and all their grounds that is one, updated, and two, is composed in a way that makes sense for law enforcement if they have to come in an event of a school emergency. So and Rachel's nodding. So I think there's technical terms that they understand better, but really it makes a common map that can be accessed by anyone that may have to come to the situation. So depending where it is, we know that multiple law enforcement agencies might be needed. And how do you communicate what your school building looks like if they've never been there? This map provides that common language, a common image, so that all schools will have that. Every school will be eligible for this based on this funding. There will be, depending on, we're through in the bidding process of what vendor is chosen, additional services that schools could purchase beyond that, but it gets everyone on the same page in terms of where they're at right now.
So everyone will do that, not everyone may do that.
Well, I guess the question would be, why would you not if it's available to you? So yes, it is.
It's not mandated that they could.
Nothing is mandated. None of these are mandated. But I do think it would be a difficult conversation to say that I turned down money and resources for school safety that's being provided. So no, not a mandate, but certainly encouraged.
Is this adequate funding? I mean, we look at all the buildings in the state of Iowa, we're talking about a lot of school buildings.
For which
And
part?
50,000 with 75 million, I'm just doing a little math in my head.
For which part of it?
It says $50,000 is available for each building.
Yes,
Potentially.
potentially.
If you extrapolate that out, you know, more than $75 million, correct?
75 million is just for that part of it.
Just that.
That's, yep, just that piece that's been dedicated by the governor through ARPA dollars is just for, and it's a blend of ARPA ESSER to make those improvements up to that amount.
Right. And the assessment is different, I understand.
That's a different.
Yeah, that's a
Yep.
different piece.
Yep.
Okay, but again, you know, would that be enough money for each building if folks would actually take the leap and do this?
So the money is going to be tied to the recommendations from the vulnerability assessment. So the team that comes in and says, these are the things that you use, then they'll decide based on what they need, how they can leverage that money to make changes. Yeah. Yeah.
I have two questions.
Yeah.
The first one is, what was the program called, the mapping program?
It's called Digital Critical Incident Mapping Technology. That's like the generic term of it. And there'll be a vendor that specializes in that. There's a couple different ones. Yeah, that's a lot of words.
The second question was, when you're talking about vulnerability and improvements made, what are we talking about, like metal detectors or cameras, or what falls within that?
It really depends on the buildings. It could be some of those things. It could be, you know, if you think of most districts, 10 years ago, you could walk into most school buildings, and most districts don't have that anymore. They have some type of check-in. Some of it could just be assessing their access points into the building and making changes to what that looks like. It could be cameras. A lot of people have them, so maybe they need more. It could be some way that they need to have their cameras connect with law enforcement. So it's a variety of things based on the structure of the facilities. It could be if there's multiple buildings that aren't connected. It's not going to, pay for a substantial physical upgrade, and the timeline of the dollars went well for it either. So there's a variety of things. I could probably get some more specific examples because that's really kind of within the scope of Homeland Security and what they look at. Rachel, am I missing any topics that have been on a call that I haven't?
That's about it.
That's kind of the high level stuff. When you think about, I'm thinking back to when we did some of this work. Those are kind of the things you looked at. You can put a lot of cameras in, and there's different types of camera services that read different things from real time to static points. And that's really something the district could decide, if there's a vendor that they have that allowed them to improve that type of service, those dollars could be used for that too.
Okay, thank you.
I have a question.
Yeah.
The digital map, how would it be accessible towards like the local emergency kind of staff?
It's all kind of housed online somewhere, and I don't know how they actually connect, but the idea is that no matter where you are, if you're given access, you can go in to see that. So it's not tied to the physical building. You don't actually have to go in and, I remember they had to come into my building and look at my maps, the papers, to figure out where things are. And that doesn't help if you're trying to bring in other people. So it'll be some sort of, not cloud, but connected electronically. And I think the connecting point is law enforcement. It's through their system. It's not the school. The school is connected with their local law enforcement. Law enforcement is connected with a broader network to bring others in.
So would it be open to the public then?
So when you're talking about school safety, these are not, there's a lot of requirements in terms of privacy with school safety, because the last thing you want is to say, here's your vulnerability, let's publish that publicly, because that's just advertising where you can be accessible. So there are some very specific code sections and rules on how that information can be accessed, and it is not publicly available for those reasons. I only got halfway through the list. Let me get a few more. There's also $4.5 million being designated for radios for schools. The first thing everybody wants to do when there's an emergency is go on your cell phone. When everybody gets on their cell phone, everything shuts down. And so they have to have the capacity to connect. There's some very specific radios, again, that are being part of a contract that's being bid out that will allow schools to all be connected. Because they'll have it can't shut down in the event that the network would go down, and those will be provided also. There will be a software program that I believe is going to be some type of app. And again, this will all be housed through public safety that will allow for some type of anonymous reporting system when there are concerns. One of the things that they want to make sure is, we have all these resources for when something happens. These are the things that are more on the preventative side. How do we pay attention to this? And this is well out of my scope of expertise. But when you listen to law enforcement and Homeland Security talk about this, there's networks and understandings of things that they can do. And then the last part is the School Safety Bureau that will be overseeing all this work. They will be engaged with monitoring that system. So when someone reports a concern about someone's behavior, a concern about a threat, a concern about something they've seen, it goes in this anonymous reporting app, and then they can follow it to determine whether or not it's valid, it's not, what the next steps are. But all of that is going to be provided as part of this big comprehensive package for investment in school safety. Other questions on any of that? Because it's a lot, but it's going to be a great opportunity for schools to get things that they need.
How many people are in that bureau, School Safety Bureau?
I don't remember. They've just hired a new director for it. Rachel, do you remember how many? Let me find out and I'll get that to you, but I don't remember. It's a team that they're going to house over there, and they just hired somebody that has been a veteran in service. I can get his name for you too. I think it's gone out in some of our updates, but I'll make sure we send that again after today's.
Thank you.
Yeah.
Are other states doing similar initiatives, or we kind of stand apart from?
It's a variety of things. I'm not sure I've seen something quite like this. With, you're trying to get something we can give you right now. It's a tangible thing that you can use and have to make a difference. Again, knowing that we're not just starting today. This is not a new conversation, but it's reminding us of the importance of this and making sure it's not just do this. Here's some resources behind it to help. The other part of this then too is we go back to the preventative side is really concerns around mental health and supporting our kids and our families, our communities, our educators. Part of this work we're going to tie into some of the work we do at that mental health center that we're supporting through the University of Iowa. Their goal is to provide resources and services and trainings to schools and service providers in the area. So some of that money will be targeted towards, as we invest in those trainings, this type of work. We did just post the registration is open for the fall summit for that conference. And so that's another good time to have those conversations of how do we talk about it over here? So we know they're both important, and that's always been the conversation. So we're making sure we're using dollars on both sides of this, knowing that this is something we can do right now. And this is a much bigger ongoing conversation that we want to make sure people have the capacity and knowledge they need and the resources available so we can take care of our kids and our educators before we ever get to this point.
And is there some kind of annual reporting of what we have, what we gain, who did these assessments, what they've done? I mean, is what's the oversight of that? Is any of that come through us or you or
It's not really
public
us.
safety?
Yeah, it would be through that bureau, I think, and probably largely tied to two parts. One, because we're using relief dollars, there's the oversight of the use of those funds. So that will be some of both. But then two, that's a really good question in terms of public safety, how they want to look at the success of this. So I think that's something we can share with that team on, how they can assess the impact of this over the next few years.
Is that something we could periodically hear about? I
Sure.
There's so much interest and need to know on this. And I think it would be good that it also came through the department and then, periodically, at least annually shared with state board.
Yeah. We will, I'm looking at Rachel again, make sure we let our team know that. And maybe it would be helpful to have a presentation from them. I always am sort of fascinated.
I was thinking the chief, yeah.
That'd be great.
Chief, I would love to hear from that.
Okay.
That'd be great.
We could absolutely, we'll get something up like that scheduled. You bet. And I think that's it. I'm sure there's plenty of other things, but those are the big things I wanted to make sure I talked with all you about today. So any other questions on that? All right,
Okay.
thank you.
Thank you, Director Lebo.
Yeah.
One thing, from public comment today, could we add to a future agenda an update on the dyslexia project?
Is that,
Future agenda.
Yes,
we can have a conversation about that too, yes.
okay, that would be great.
This charter school issue might also be something that we need at least to listen to. I'd like to have some.
We have an agenda item today on that.
I'm sorry, I apologize.
That's-
We're good. Do my homework better.
Okay, we do have the consent agenda to approve, which includes the minutes from June 9th, appeal decision with open enrollment at Linmar, and rules for chapter 56.
I move approval of the consent agenda.
Second.
Been moved and second. Any conversation? Hearing none, all in favor indicate by saying aye. Aye. Opposed? The consent agenda is approved. Next item on the agenda, we have an appeal decision about a challenged book, West Des Moines.
Before starting this agenda item, I'd like to acknowledge the work of my colleague Kelly Rice, staff attorney from Iowa Vocational Rehabilitation Services. She joined us today in case there were any questions. Her team did an exceptional job in doing a thorough rewrite of Chapter 56. So just wanted to bring her and her team's work to this board's attention.
Yes, thank you.
Next agenda item is an appeal decision regarding a challenged library book. I've provided you with the administrative record as well as the proposed decision. The proposed decision has two layers. First, a question of jurisdiction. Valley Southwoods ninth grade high school is a single year building. And so if you're no longer attending that building based on prior board precedent, you are no longer aggrieved by any decision. The second layer was the reasonableness of the action that the board took. And the attorneys who are both here today and will be available to present oral argument and answer any of the questions that you may have of them directly. The question about the scope of review. Does the board exercise independent review, make its independent judgment, or does the board exercise more deferential review? And based on Iowa Supreme Court precedent, this board's prior precedent, the scope of review is deferential. In the words of the Iowa Supreme Court, the local board's decision is prima facie correct. And with that,
What do you mean by that?
it's presumptively correct. That to overturn it, there needs to be a reason to overturn it rather than I disagree with it. Attorney Christy Latta represents the school district. She is here, the school district and board. She is here today. Attorney Alan Ostergren represents Ms. Patrick. He is here today to address questions about standing, scope of review, as well as the reasonableness of the board's action. But the scope of review, as presiding officer, once I looked at the scope of review, the board's policies, and weighed the pros and cons for keeping the book, removing the book, the merits of the book, with that deferential scope of review, my recommendation to you is that the decision of the West Des Moines School District Board of Directors, which was not unanimous on this question, by the way, be affirmed. And with that, I will yield the floor to my colleagues in private practice for oral argument. I will, practice is to start with the counsel for the moving party, Mr. Ostergren. And you may speak from wherever. Okay, thank you.
Good morning.
Good morning.
Morning.
Mr. Mays, I'm sorry, before Mr. Ostergren begins, is it practice to allow the speakers to complete their arguments before asking questions, or is this more of a back and forth?
It's your board meeting.
All
so
right.
it's your right.
And certainly if a board member has a question, please feel free to ask it during my remarks. This is formal, but it's also informal here in this meeting. My name is Alan Ostergren. I'm president and chief counsel at Kirkwood Institute, which is a public interest law firm based here in Des Moines. I'm here on behalf of Terry Patrick, who's seated behind me, a parent of a student in the West Des Moines schools. We started this appeal process, and I want to give her credit where credit is due. She got almost all the way through this on her own without a lawyer and did a great job. I'm here today pro bono on this. I'm not charging her a penny because of how important this issue is. On the question of standing, we had cited to the administrative law judge an Iowa Supreme Court decision that takes a much broader view of standing than what has been argued here. It's a case from 1955. With all due respect to the board's prior decisions and to what its administrative law judges have recommended in the past, as this board, I think, probably knows or should know, that the legislature has not granted this board the ability to interpret these statutes for itself. The Iowa Supreme Court has said that any parent with a connection with the school district is aggrieved for purposes of challenging a decision of a local school board, and that's what Ms. Patrick is. On the merits of this, I was struck at the hearing that was conducted before Administrative Law Judge Mays. In asking the superintendent of the West Des Moines schools, give me an example of a book that would not be appropriate to have in the library for middle schoolers. Give me any kind of objective criteria of something where you would say there's no educational value to this material. It is not appropriate for the school environment. And she could not come up with a single thing. Not one thing. Not one objective standard as to why this would be inappropriate to have in a middle school environment or any school environment. Now, what my professional colleague, Mr. Mays, has told you is that it's a deferential standard of review. That's fine. But a deferential standard of review presumes that at some point, somebody has actually made some decisions based on something more than just shrugging their shoulders and going along with whatever is happening. And that's exactly what this process is. There's a building committee to approve materials, and they all say, well, I guess it's okay with us. And then another level of review and no objective criteria. And then it goes up to the school board. And there's no objective criteria at any level. And then you're asked just to defer to what? Now, Mr. Mays did not include in the administrative record the actual book because of purported copyright issues. I've got a copy for everybody, but we're talking graphic depictions of sex acts. And I want to be clear, it's not because it's two boys in here. Okay, that's not the point. That's not the point of this. I don't care if it's males and females. I don't care if it's adults, whatever it is. It's not same sex, opposite sex, or anything like that is the issue. The issue is we all understand the context that this is happening in. Parents feel that the public schools are absolutely out of control and disregarding their interests and what they want to see.
Mr. Ostergren, wouldn't the parents have a recourse at the ballot box if that's so far outside of their standards?
They do over time, and reform is coming. And reform is coming. And really that gets into a point here that we all know reform is coming one way or another to public education. It has come and it is continuing to come. And the question is, will the infrastructure of public education in Iowa show any ability to reform itself? Is there going to be any ability to do that? Any sliver of anybody in authority standing up and saying, you know what, maybe we're going a little too far. Maybe we're sexualizing children too much. Maybe we should listen to people and not just assume that because we're credentialed, we know everything. That ultimately is what this is about. And if reform doesn't come from within the public school infrastructure, it's going to come from without it. And you're probably not going to like what that reform looks like, but you've lost almost every chance you have to show that you can fix yourself. Nobody has taken responsibility in the West Des Moines schools for an actual objective reason why this kind of stuff needs to be in a school library. Nobody. And then they're going to come here today, and my colleague is a very fine lawyer from a very fine law firm. And she will cite to you deference, and they follow the rules, they follow their procedures. The whole thing's broken. You are appointed by law to superintend how school boards function, how the system of education functions in our state. And you would make an enormous impact by simply saying, you know what, this is too much, it's too far. Those are my comments. I'd be happy to answer any question that you have. Yes, sir.
Just a follow-up on my first question. If change is coming, if that's inevitable, why does the board need to act at all? Why would that be less legitimate than action here?
You don't, it's up to you. Deep down, if you don't act, it makes the example for why reform is all the more important from an external source. If you do act, it shows a capacity for the public school infrastructure to fix itself. You don't have to. I can't make you do anything. You don't have to do anything.
I suppose my question is, assuming you're wrong about the external changes, let's say the voters in West Des Moines have an opportunity to elect new school board members and they don't do anything about this, and we, in a bureaucratic appeals process, change it for them. How do you know that this was the right change versus what the will of the voters, against the will of the voters that have elected the school board members that are currently in office and presumably if this hypothetical plays out, would still be in office after an election. Wouldn't that make our decision to supersede their will illegitimate in some sense?
No, because you're here right now with the authority to review the decision that was made there. Yes, in time, what has been happening and is continuing to happen is parents are waking up to how broken aspects of public education are and are trying to fix it. Yes. Okay. But if the answer is, oh, they're elected, therefore, who are we to question their decisions, then we should end the meeting and you should resign from this board, because what's the purpose of this board then, if not to supervise those decisions?
Do we know of any schools in Iowa that's actually established standards for library books? Do we know of anybody who's sat down and these are the criteria this book must meet?
I don't know that, and I would like to know the answer to that question. I certainly got into this pretty late in the process. I can't answer that.
I'm a layman. I don't understand standing completely. I don't always get it. So this student, would this student have access to that library even though this student isn't in that building? So, I'm an 8th grade student, could I go to the 9th grade building and say, gosh, you got a great library here, I'd like to check out a couple of your books? Could I do that?
I don't know the specific answer to that question. I'm going to assume no. Okay. It's a 1-year building. There's a process in place. This is West Des Moines decided to have a single grade building, which is fine. I'm sure they have a good reason for that. What standing means is your ability to go into a proceeding to contest some application.
Yeah, I understand that.
Yeah.
It affects me, it directly affects me in some way. So my brother could check the book out and give it to me. My sister could check the book out and give it to me. My friend next door could do that. I could still get the book.
I think, right. I mean, once it's checked out, it can go to anybody, obviously.
Okay.
So I have a question. Can you tell me why we should even be talking about the merits of this when 290.1 talks about you have to be the parent or guardian of an affected student in that school? Why should we get to the merits of it? If your client had her child in the school, obviously we'd be okay. But why should we do that in this case?
Because the Iowa Supreme Court has said that someone with a connection to the school district like she has, it qualifies as an aggrieved person.
Notwithstanding the statute.
What I'm telling you is that's what the interpretation of the statute is in the court case that we cited, the administrative law judge.
And 1955.
Well, that's how court decisions work. They're in place until they're overturned.
The statute is much newer than the court case.
How the court defined the word, interpreted the word aggrieved, was somebody with a connection to the school district could pursue the appeal to the state board.
Does the decision of the school district and school board in West Des Moines affect or bind other schools in the district? Or is this just limited solely to Southwood?
So the most direct application of, if you were to reverse the decision, then that directly would only apply to the West Des Moines schools. That would become an administrative precedent. And then work would go on with other school districts, and perhaps other school administrators would rethink decisions that they had made in light of a board decision along those lines.
What I mean is if, for example, I don't know the circumstances of the student involved here. It's a 1-year program. Presumably they went on to the 10th grade. My guess would be at Valley High School. Is that book available at Valley High School? And does the decision of the West Des Moines School Board in determining the appropriateness of this book in the library at Southwoods, is that also, because if the student was agreed to Southwoods and the book is in the library at Valley, the student would still be agreed, correct?
So there's the direct legal effect, which is much more narrow, then there's the practical effect. And I'm confident that if this board were to overturn the West Des Moines school board's decision here, then my colleague would have, my friend on the other side of this case would have to have a conversation with her client about the use of that material elsewhere, as they would in every school district.
Okay, thank you.
Is the book in any other building in the district?
I don't know. On our administrative record, it's at this middle school building.
Recognizing part of the decision noted that reasonable minds could differ on whether the challenge book should remain on the shelves. Was there any other public comment for or against the book being retained?
There was I think a very full and vigorous debate at the school board level with concerned parents. Ms. Patrick is the one who took on the responsibility to get this to where we are procedurally, again, without a lawyer helping her, which I appreciate. But yeah, and as was noted, this was not a unanimous decision of the school board. This was a debated point there, and the community was engaged with it. Obviously, the vote went the other way, which is why we're here.
How would you gauge the public perception in that debate? So I understand the school board's decision, but how would you reflect the public debate to the school board?
I think it reflects the debate that's going on all over Iowa, that parents are beside themselves at this feeling of loss of control of what's going on in public schools.
But was the debate to the school board for or against keeping the book in the library?
I can't give you an exact breakdown of the comments. I know there was significant opposition. I can't represent whether or not there was comment in favor. I don't know that. I have no idea if I'm over my 7.5 minutes. I'm sorry.
You are.
Okay.
Are there any other questions? Hearing none, we'll go to the other. Thank you.
Thank you very much. Thank you.
Hello. My name is Christy Latta. I'm from the Allers Law Firm, and I'm here on behalf of West Des Moines School District. I guess I'd like to start with a few comments from Mr. Ostergren. The building at issue is not, I guess, what I would characterize as a middle school building. It's a 9th grade building. So it's, for most purposes, considered high school level. So it's a 9th grade building, freshmen. 14, 15-year-olds, I think, probably be the general age range that are there. I do disagree with the characterization of the superintendent's testimony at the hearing. I think if you looked at the testimony in its totality, it was clear that we weren't there to talk about any other book except for this one. And so I personally don't think, that idea of wanting to sort of speculate about something outside of what could be appropriate, what couldn't be, really not, necessarily the forum for that particular conversation. And then, with regard to, I guess, how we got to where we are, this is the appellant's 6th bite at the apple. Okay. So we started with the complaint that the appellant made internally pursuant to the district's complaint procedures. That was reviewed by a building level committee. Lots of school districts in Iowa have these sorts of policies for how to reconsider library materials. So the fact that Mr. Ostergren says there's no objective criteria is just not the case. In the record before the administrative law judge, policies were submitted that talk about materials, controversial materials, objectionable materials, what factors are to be weighed in those situations. And then there's even this policy and protocol for what to do when you get a complaint. So the complaint came in, it was reviewed at the building level. There was most definitely not any sort of cursory review. I mean, the administrative record is clear that there was a lot of conversation at that building level committee about what to do. The committee ultimately decided to keep the book on the shelves of the library. Again, just to be clear, not required reading, not part of the curriculum. It's just sitting on the shelf in a library. So optional, voluntary, all of that stuff. And as the superintendent testified at the hearing, to the extent that any parent didn't want their child the ability to check that book out, they could make a note of that and that would be accommodated. So that's, I think, another important distinction here. But, with regard to that policy, after the building level committee decided to keep the book, the appellant took it to the next level, which is an administrative committee. It's like a teaching and learning advisory committee is what they would call it. So the building level committee's decision was reviewed then at the administrative level. The administrative level also put together a decision affirming the building committee's decision. That decision then goes to the superintendent. The superintendent affirms that administrative level decision. So that's about, the third iteration of review. At that point, then that decision was further appealed and it went to the school board. So then we had a school board special meeting to talk about this particular issue and whether or not the administration's recommendation should be affirmed. So that's the fourth level. And the appellant appeared there before the board. There was vigorous discussion, public comment on all sides, lots of back and forth and dialogue between, the board members and the appellant. So there was most certainly, a consideration of all of the factors and all of the dynamics that were at play. After that, the board ruled, as was said, not unanimously, to keep the book in the library. Then the appellant appealed further. So that was the fifth time at the state board level with the administrative judge. So the administrative law judge heard all of this, reviewed the record, and agreed to affirm the decision of the school district. And now here we are again at this particular point in time. And my two comments that I guess I want to make sure I communicate to you is that first and foremost, I don't know that we get to the merits here. I think there's a jurisdictional issue with regard to the fact that this is not a parent of an aggrieved child. The child doesn't attend the school where the book is at. For that reason, they really cannot be aggrieved. And I guess what I would point out is that case from the 50s that was cited by Mr. Ostergren predates the idea of 290.1's affected and aggrieved. So it isn't just that you're aggrieved, you also have to be someone who's affected. That's what the statute says in order to, retain jurisdiction. So I don't know that we even get to the merits because I don't think that there is jurisdiction for the state board to hear something of this nature. With regard to, could someone's sibling check it out, or could you in some way, shape, or form have access to the book? Sure, but I guess I'd say no more than going to the public library or no more than pulling up the internet, right? So that idea of having standing requires something more direct. So again, I don't really know that we get to the point where we're at the merits on this particular case.
Ms. Latta, if I could just ask you a question about that. When did this student cease being an agreed party by your lights?
How old is your child now? It was prior to the institution of this appeal. Sophomore.
So if I read the record correctly, you appeared before the administrative law judge on June 8th. And so presumably this student had graduated and left Southwoods at that point and was not an agreed party by understanding of that.
Correct.
Did you brief that issue?
Yes. The administrative law judge requested supplemental briefing on that issue.
Or before the fact?
After the hearing.
As you went to the hearing on June 8th, you felt that you didn't have a standing issue at that point.
I was thinking that there was a possibility of that, but since we had already seen the whole process through at the board level, we went forward with the hearing. And I guess what I would say is that at any time there's an issue with jurisdiction, the state board is obligated to raise that. You aren't really able to waive the question of jurisdiction when it comes to an aggrieved party.
In this particular case, do you recall when the first bite at the apple took place, I guess, to use your language? What date was the complaint first made?
I have someone here from the district. I'm trying to remember. It's in the record. I don't know specifically when.
To frame my question more broadly, we've got a school it's only there for 9 months. And this appeals process now has taken in excess of 10.
Right.
To get where we are now. So if that's the case, any student or parent who is aggrieved at Southwoods would lack jurisdiction necessarily. That's our understanding of standing, correct?
Right.
They'd only be able to appeal to a certain point before all of the other forms of appeal to which they would legally be entitled otherwise are out the window, simply because of this kind of curious nature of this school.
Right. Well, I think to the extent that the student is an aggrieved party, perhaps at the time,
Right.
the time that the claim were to accrue,
Yeah.
then I think that, you would be able to retain some sort of sense of control at that point and authority.
But then they lose all of their legal recourses simply by dint of the 1-year nature of this school.
Yes, I suppose so.
Never be resolved if it continue. Like no student, no aggrieved party who brings up this very same issue at this very same school ever will be able to come here and get find recourse.
No, I don't believe that's correct, because I think what you'd be able to do is file the complaint as an aggrieved party under 290.1. So, whether or not there's the internal process with regard to the school district, right? That's a separate question. Those are internal procedures with regard to the board and their policies. Whether or not then there's that board decision that would allow for the aggrieved party to be so aggrieved under 290.1 at the time, I think is a separate issue.
So if I'm following this a little bit, just if I file this complaint when my student is in 8th grade, and I can't say that my son or daughter is going to be affected by this decision because they're going to that building next year. So I want relief. Is that out of line? I mean, I'm saying that, would I have say my son's going to that building next year. That book is on there. It's like my son's standing on the interstate. Here comes this truck and it's going to run over him unless I move him. So is the obligation on my part to move my son to a different building? Is this the only building? The only 9th grade building?
I think at the time of this issue, it was the only building with the book. I think there may be other buildings with it, potentially at the high school level. I just don't know for sure.
Yeah, I'm following that conversation. I mean, when would you ever?
Well, to your question, that's not the precedent of the state board. The state board has said, it's not just that, hey, you might be a kindergartner and we put together a policy for varsity football and you don't like it and you get to see the truck coming, so to speak. You have to actually be affected or aggrieved.
I hear. You said that there are written policies about the books when we select those books. Did you bring that, or is there?
Yes, that is in the administrative record.
Okay, in the record. Thank you.
Yep.
Was the child ever a student in that building?
Yes.
So when she started the complaint process, was the child in that building?
No, he is a sophomore at that time.
He was a sophomore. Okay. So he had already left the building.
Yep.
Was the book on the shelves while he was a student at that building?
I don't know. I'd have to go back to the school and look. I feel like it probably was, but I don't know.
Yeah, and I don't know the answer to that, but I think what is clear is that this was a 10th grader not attending Valley freshman 9th grade school when the complaint was brought. So just to make that totally clear, it's not a 10th grader now, right? The child is not a 10th grader now.
Your understanding is that if presumably a hypothetical 9th grader day one files a complaint, even if they graduate and leave that school and go on to another grade.
Yes.
That they would maintain standing.
Yes.
And so,
Yes. I don't think you lose it because, it took too long, right? Yes, I think that's okay. Now I understand, I think what you were asking. No, I don't think the board loses jurisdiction because all of a sudden, it's been timed out. No, I think the reason the board never even had jurisdiction was because the student wasn't even in the school when the complaint was filed about the book in that school.
I understand. Thank you.
Yes.
May I ask a question of the district representative?
Yes.
Could a student go to that building from another building and check out the book?
Not that I'm aware of. We do have students that can go between buildings because they're being served in one class or another class between our buildings. They could go there. But I don't think that they can just walk in. Positive about that, but I don't think so.
Thank you.
Okay, so again, I stand by the jurisdictional piece here, but moving to the merits, if you were to want to go to that portion. In this case, the board ultimately is who you're reviewing. So we had these 5-6 bites at the apple, but ultimately if it's the board's decision that you're looking at, the board here made a determination, not just based on the pictures that were shown to you, but based on the book as a whole. So the board decided, and all the committees before it decided as a whole, in its entirety, they decided it had value, okay? I think that if it had gone the other way, if the board had decided not to have the book, and certainly I'm sure there are districts that might make that decision, I would venture to say I may be sitting here anyway, right? There would be someone on the other side who would be upset that it's not available. And so I think that to me is very striking in the sense that this is one of those situations where, reasonable minds can differ. And you might not like that book or might disagree with it, but the people that were charged with making that decision, and not just the board members, right? But, all the committee members and all the administrators all the way on up, spent lots of time on that, looked at the book as a whole, right? and made that determination for this particular district in this particular case. And so I think what the argument that I'm trying to make here is not so much, in support of the book itself, just as if I was sitting here with a different appellant on the other side, I wouldn't be, saying that the problem is with the book itself. I would say that the issue here is one of a decision that is vested with local school boards, right? These are the people that are elected by the community in which they live. They are elected to serve those people, and they're responsible to their constituents. They listen to those people and they get that feedback. And so when they make those decisions, I think, yes, if there's dissatisfaction, if someone's not happy, the remedy is at the ballot box. I think if there's dissatisfaction or someone's unhappy to a certain degree, they can make another choice then about, whether or not that's a school that they want to attend. They can take steps to say, I don't want my child to check that particular book out of the library. So what I believe the appellant is asking for, if you were to reverse the decision based on the merits, it would be a sea change for the way that this prior state board has acted with regard to its precedent. It has always been, for the 16 years I've been practicing law, it has been, the idea is, look, there's a zone of reasonableness. It's like a football goalpost. And, you might be a little on the left or a little on the right, maybe down the middle sometimes. But as long as you make that football go through the goalpost, if you're within that zone of reasonableness, then this board will defer to the decision of the local board, right? It's only in those cases of an extreme abuse of discretion. And that's just not here. It's just because you strongly agree or might be, the loudest one in the room doesn't make the decision one that isn't supported by some sort of reasonableness or rationale. So I guess that's what I would really ask, is that you consider, the idea that the precedent longstanding has been not to substitute your decision for that of the local board, but rather to, look at what the local board did and simply affirm it based on the idea that they did their due diligence. They looked into it. They followed their policies and their protocols. And regardless of the outcome, it's within that zone. It's within that zone of reasonableness. The idea of essentially being able to second guess and substitute one's judgment would have extreme consequences, I think, for every local board and every decision they make, not just with regard to what's on the shelf in the library. Thank you so much. Are there any questions?
Thank you.
Yes, thank you.
Thank you.
I was on a plane in South America last week, so that's why I'm still wearing this. I don't want to bring any souvenirs back and share them. You've heard arguments of counsel. Just for clarification, the entire administrative record was made available to the board: exhibits, briefs, motions, the complainants, the affidavit of appeal itself, including all the attached exhibits, as well as my notes from the trial setting, the scheduling call, as well as the hearing itself. With that, my proposed decision is just that: proposed. You are final agency action. If you have any final questions for me or either of my colleagues, I'm at your disposal.
So I have some procedure questions for you, and take this issue aside. For me, it's just better understanding our role, because there was an appeal, 3 or 4 board meetings ago that I probably had some issue with. And so I just want to understand. So for us as a board, is our only role just process? So if an appeal comes to us, our role is just to review it to make sure that it followed the process, or is our role to actually look at the merits and give an opinion or not?
It's both and, but the question about the merits goes to the rather robust argument about scope of review. Like how closely do I look at the merits? How much does this board substitute its judgment? When is it permissible to? This board has reversed on the merits before. It has reversed on the merits before regarding bullying and harassment, which is no longer part of its jurisdiction, for open enrollment cases. The appeal that was on your consent agenda earlier today, it has reversed or modified local board decisions on discipline. In one notable case involving the district before you today, where this board found the local board's decision was objectively unreasonable. That the discipline imposed was objectively too harsh, but that this board made a finding that no reasonable mind would have imposed that discipline. So it's not just a process review. Process is important, but it's also looking at the merits, but the looking at the merits is if reasonable minds could differ then.
Okay, so this issue aside, if we had concern about an appeal, then we could take a side that isn't just, oh, you followed the process, so we're just going to go along with what you had to say. I mean, we could take a side to where we can overturn it. And you're saying it has happened before.
I mean, you are final agency action. It has happened before. The parties have judicial review rights. Your final agency action would be subject, regardless of what your final agency action is, your final agency action is subjected, could be appealed to district court in Polk County.
Okay, that's what was going to be my other question. So let's say today, again, I don't want to talk about it based on its issue, but just in general, if we just said, yeah, we agree, then the people who brought this case forward in the appeal, what's their next path? Or just
as mentioned in the
just going to court.
As mentioned, the next step available in the Iowa Administrative Procedure Act is a petition for judicial review in district court, either Polk County or where the parties reside.
Along those lines, if we disagree with a portion of the opinion as you wrote it, or take issue with it in some part, is it possible to amend it? Or if we disagree with the finding entirely and overrule the board's decision, what's the process for issuing a new opinion, and what does that look like?
Historically, when this board has modified or reversed a proposed decision, the administrative law judge receives directions from the board and brings a new decision back to you.
And as a matter of appeal, if this is going up, before a district court judge, what part of the record did they have? One of the things I was dismayed about is that I didn't actually have, there was some information substantively about what the board members discussed below and what their thought processes were, because it's very hard by my lines to determine whether someone's being reasonable or unreasonable if I just have their yes or no. How they came to that conclusion is significant to me. So how much of our decision here will be available for appeal? Higher than this? Is this all memorialized and will be part of the record for them, or?
Your minutes, your record of proceeding would be available to district court.
Mr. President, I'm not swayed by the argument that the parent has standing. I don't believe she does. I also believe that 290.1 controls the rules of outstanding, and that we're bound by the most recent legislative rules in that regard. My suggestion is that we affirm, but that we strike everything that starts with merits from pages 3 through the end, so we get to the order. We simply don't have jurisdiction. This may be a very interesting question. It's very political. It's very timely, but this case isn't before us, in my view, because we don't have jurisdiction to hear it.
And you're saying that because you don't think they had standing?
Correct.
Okay, I just want to make sure I'm following you.
Correct. I don't want to pass on the merits one way or the other. I don't think we can.
I just a couple of comments. I'm really sorry that we have to get into this discussion.
We have a point of order to, you made a motion.
That's a form of a motion.
Okay,
yes.
is there a second to that motion? Hearing none.
My apologies.
No.
Good. I frequently get ahead of myself. First of all, Counselor, you did a heck of a job of getting good information out to us. I appreciate what you sent us. Seems to me like it was spot on, all the things that helped me as I tried to work through this. And so, Counselor, I can't believe you've been practicing law for 16 years. You're much too young.
Oh, well, thank you. Let the record reflect.
I think we're right. I think reasonable people can make reasonably different conclusions, draw different conclusions concerning this. My personal opinion, the book shouldn't be on the shelf. And not so much because of the material. I just, at that particular age, I think kids are pretty vulnerable. And I just don't think it has any place on that end. And I think in education, we get into these arguments, as the counselor presented, we start arguing about the wrong things. We're discussing the wrong things, and we're spending time on the wrong things to me. Just have to make better decisions to that. But I understand they're reasonable people, and they made a reasonable decision that they thought was best for their district. And I really appreciate that. I'm going to oppose this, but again, it's just my feeling that we have to begin to look at these issues and say, in what ways does this help our kids, or is it more divisive than we really want it to be? And it's going to split our community. There's a lot of other things we should be arguing about or discussing, I should say, than this issue. Thank you.
Is there another motion from the?
I'd just like to add that I think everything that's about the merits here is us giving advice to people, or an advisory decision about a matter that's not properly before us. I hope somehow we come to a conclusion that we don't have jurisdiction, because I think it's the dangerous precedent to start saying what you think about things not properly before you and the law of unintended consequences. There are other ways that this can be addressed besides us ruling on the merits of something that's not properly before this board.
What's the advice? You said that we should be giving advice. What's that advice?
The advice is all the comments about the merits. Commenting on the underlying dispute about whether the book should be on the shelf or not.
You're saying it shouldn't be there because we shouldn't even be looking at it.
No, I'm not saying that at all. I'm saying I'm saying there's no jurisdiction, so we don't make any comment for or against any of this.
I just want to make sure I'm clear. And you're saying there's no jurisdiction in your mind because that's go to that school.
The appellant has no standing.
Got it. Yep. I just want to make sure I'm tracking you.
I try. I mean, I take this seriously, and I think we should try to do it as legally as we can. And I don't think we should overstep our authority. I think we are if we rule on the merits.
But there is a question of jurisdiction. And that could be,
there could be. That's why I made a motion and nobody seconded it.
So, I mean,
you can all agree that they do have standing. I'm saying under 290.1, they do not.
we may.
Like we don't on open enrollment anymore. The statute changed.
As a board, we may decide that we have standing and we decide on the merits here. And if we're wrong about the standing issue, somebody in a black robe is going to tell us that. And our merits decision won't have any effect.
They are.
And we may be tilting our hand or dissuading further litigation on the issue by issuing an order or, by forming an opinion about something that ultimately is not effective because there's no standing. But I don't think, we owe somebody a decision here today. There's parents involved, there's children involved, and I think that that's our responsibility. So
I just don't think we just pass it along for the parties to go to court. We should decide whether we have standing or not. If the board believes we do, then I can vote no.
then in that case, I move to find that the board does have, the claimant appellant does have standing and the board should rule on the merits.
Thomas, should the board decide to?
Point of order, please.
I'm sorry.
There's been a motion that the board does have jurisdiction. And can you restate the last part?
And that the board should move to decide on the merits.
Okay. Second. It's been moved and second. Now we have discussion. Rod?
Thank you. Thomas, should the board decide to overturn the local board's decision, what impact does that have on the building? Would that require the book then be removed from the library, or would they go through an appeal process to the district court themselves? Or could they? I'm sorry, not would they?
Administratively here, your board's decision would become final agency action. Whoever is aggrieved and appeals to district court could ask for your decision to be stayed. And there are specific procedures under the Administrative Procedure Act in district court to allow your decision to be put on pause while judicial proceedings move forward. So the question of what happens after your decision is largely between the parties and whether or not they choose to go to state district court. And whether or not the state district court, under rules about entering a stay or putting your decision on pause, whether or not they grant, whether or not they put your decision in timeout.
Thank you, Tom.
Further discussion?
Could I have the motion repeated back? Because I didn't understand the second part, but maybe I just misheard.
I move to find, for the board to find that we do have jurisdiction and so that we could proceed to the merits.
Point of order, Mr. Chairman.
Yes.
Can we do that without splitting it? Kind of said that. You said that we want to split this and take this issue of jurisdiction first. But do we have to split that formally? Do we have to vote on that? And then?
We're going to have to vote on his motion because it's been second.
Okay.
I do have a comment. I would contend that we do not have jurisdiction. I would also contend that the board is treading on thin ice to say we have jurisdiction. And I would also contend, I'm not arguing the merits of the case as far as whether that book should be on the shelves or not on the shelves. I'm just thinking if the board decides we have jurisdiction in this case, it will become a book review for the state of Iowa. If that's where we want to be. That's my opinion.
And can I ask your opinion on why you don't think we have jurisdiction?
We don't have jurisdiction because the student is no longer a student at Southwood. We don't have jurisdiction because the appeal was, or the original contention was when he was not a student at Southwood. It was after the fact. If we would start when he was a student at Southwood, I would feel differently about it.
Call a question.
It's been moved that that the state board does have jurisdiction and that it should examine the merits of the case. I'm paraphrasing. Is that close enough, Karen?
Yes, thank you.
Okay. We'll have a roll call vote. Yep.
Bradley?
First, let me say I have a grandson going into middle school this year. He'll be a ninth grader. The materials that I reviewed are offensive. I find it hard to believe that so many reasonable adults found it to have any true literary value for my grandson or anybody of his age. I think one of the points made by the aggrieved party was that Amazon lists the book as an adult book over the age of 18. I looked it up on Amazon. That is how it's rated. So I think it would be akin to a teacher showing a movie that was never intended for ninth graders in a classroom without the parents' knowledge. So I'm going to vote yes.
No.
Yeah.
Nay.
Could you just be just a little bit louder?
Sorry, May?
Yes.
Peterson?
This is just for the issue of jurisdiction? correct?
No.
No, it's your whole motion.
Okay, so I vote not to affirm the decision.
It's clear, it's clear. Let's clarify what we're doing.
Yes or no to your motion.
My motion is on jurisdiction. And
No, it is-
We're voting,
Your
do we
motion
have
also
more?
goes to merits.
Okay, proceeding to the merits. Yes.
Robbins,
No.
Van Gundy,
No.
Dale,
Motion fails.
I would like to move again that we find that there is no jurisdiction for the reasons John just stated. Student was not a student when the appeal commenced. And that there's no jurisdiction under chapter 290.1. And we should not get to the merits, just to be clear.
Motion's been made.
Second.
There's a second. Any further discussion?
I'll just share one thought. I think the point of the reasonable minds could differ, and the fact that the school board did entertain public comment on this issue and that opinions were shared in that public forum is really important. I also think that having parental control in the library and that parents have an ability and a mechanism on a local level to express their concern and have control over what access their children have to materials in the library is really important. So having local control over those issues, and as a parent, having local control over those issues is still a protocol that the jurisdiction retains. So there's parental awareness issues on both sides of this issue that I think as a parent having a child in any district that a parent has to have ownership of. So that's just the thought that I share when it comes to merits.
Okay, so we have a roll call vote on the motion that the plaintiffs do not have the jurisdiction.
one question, who second?
I did. Thank you.
So roll call vote, please.
Yes. Bradley,
Affirmed.
Pauls,
Affirmed.
Kane,
Aye.
May,
No.
Peterson,
Nay.
Robbins,
Yes.
Van Gundy,
Aye.
motion carries.
Okay. We will move on.
So President Robbins, I will have a revised decision for you, noting that the board's vote was limited to the question of jurisdiction.
Yes. Let's take a 10-minute break. It's 22 now by my computer clock. We'll come back at 10:32.